Thanks very much, Carolyn, for joining us. Really appreciate meeting you, and it's so interesting to hear about your work and what you were saying about the native title discussions in the Pilbara. Immediately made me think of the Juukan Gorge situation, and the whole. You were talking about mining companies riding roughshod over Indigenous people's rights, and this sense that Indigenous people were just extremely marginalised and to some extent remain marginalised. And I'd just be really interested if there's any sort of you must have had some inside knowledge or some perspectives on the Juukan Gorge incident where to have 40,000, 50,000-year-old artwork just destroyed with such indifference is really quite shocking. You know, that whole sense of the depth of relationship that comes to country and place through that sort of timeless connection, and to have that just so wantonly disregarded is such an abuse of power, and it shows some of the ongoing racism and cultural difficulties that we have in Australia. Thank you.
Yeah, exactly. I mean, the thing about the destruction of Juukan Gorge was that it was perfectly legal. What happened was there was under our Aboriginal Heritage Act, which is still in force from 1972, the minister is able to grant consent to the destruction of sites. And at the time Rio got the Section 18 consent, the full information about the site was not there, but even what they had indicated that the site had evidence of 20-something thousand years of occupation. But nevertheless, the minister granted consent. And then subsequently, with excavations, they discovered that it was 46,000 years of occupation. But even then, as that even what was before the minister, the consent was given, and that's the trouble with the Aboriginal Heritage Act, and also ultimately the Native Title Act, because with the Native Title Act there is no right of veto. So you just get a period of right to negotiate, and people are forced into the position where they know that if they say no, the odds are it's going to go to the tribunal, which is going to probably grant or allow the future act to proceed. And if that happens, it happens with nothing in exchange. So you're often in a position where you take what you can get because it's better than what's going to happen otherwise. And even under the Act, even if the tribunal says an act can't proceed, the minister still has the right to step in and override that. So that's the uphill battle that you're facing with native title. But I mean, so in that particular case, an agreement was reached, but in the hope that the minister would have said no to a Section 18.
A very tough situation, really, Carolyn, with legislation that, at least around Australia, it's starting to be said that the Heritage Act needs to be updated and needs to be improved. And that's one thing that's come out of that ghastly destruction.